any of these conversations happening online, because these are the things that the government is using and citing in that case, bro. You see what I'm saying? It's just some circumstantial stuff. He said, yo, don't put nothing in my name or something like that. That's what Durk said, you know. That's it. But we got other people messaging each other, whether they part of OTF or whether they close to them. They like, yo, what's up? He sent the bread. Yo, when that bread dropping, da, 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 when it's landing, yo, it's going to land, chill. You know what I'm saying? It got things like that, which is kind of like tying them in because it's OTF, but it's really not him. It's not like you got a person say, yo, it's Durk did it. He did it. But they're saying CW1 is saying that Durk did this. So did CW1 say that Durk did it straight, or did CW1 kind of admit to it some way in a message, in a voicemail or voice note? Because that's a possibility too. So we have to think about those two things. All right, cool. Let's get back to the work. All right, cool. That's crazy though. They called them admissions though. All right. Although the court can deny the defendant's motions on the merits, it needs not do so here. As discussed further below, the defendant has a standing only to challenge the seizure of evidence from the accounts that belong to him, the two accounts at issue. Because the government does not intend to introduce evidence seized from those accounts at trial, the government respectfully requests that the court deny that motion. Wow, they saying they ain't even going to go into the accounts? Wait a minute, let me read that part again. The defendant has standing only to challenge the seizure of the evidence from the accounts that belong to him, which is, i.e., the two accounts, the iCloud and the X account. But because the government does not intend to introduce evidence seized from those accounts at trial, the government, they basically saying what we got, we don't even need that. So you might as well just deny that too, because we don't even need that. Based on, we're going to see what they're going into now. Boom. A, argument. The defendant motion is moot. The Fourth Amendment guarantees the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Yes, Smith versus Maryland. That's the citing. The capacity to claim the protection of the Fourth Amendment depends upon whether the person who claims the protection has a legitimate expectation of the privacy in the invaded place. They go into another case. It is well settled that a defendant does not have a reasonable expectation of privacy in someone else's email or online account. They cite another case. Fourth Amendment rights are personal rights which, like some other constitutional rights, might not be vicariously asserted, noting that co-conspirators and co-defendants have been accorded no special Fourth Amendment standings. They go into another case. Okay, Chief District Judge Gee ruling that the defendant lacks standing to challenge the warrant as to the 3 Gmail accounts that do not belong to him. Okay. In this case, a person has no expectation of privacy in another person's email account. Okay. So you're talking about the other people? Hold on. Let's figure this out. Why are they citing this? Because Durk and them are talking about their own cases. Okay, here the government has reviewed the evidence seized from Banks's X and iCloud accounts and determined that it will not seek to admit in its case in chief any such evidence. The defendant has failed to submit a declaration alleging possessory interest in the other iCloud accounts search pursuant. So the other iCloud accounts is what they're pushing on. Okay, they saying basically those two that they're talking about, we don't care, because these, whether they're associated to you or not, they're saying, but you don't have no business in somebody else's email. You cannot be trying to get things thrown out for somebody else's email. You don't have no rights over this. That's why they just cited that up here. So it goes to show you what they're trying to use. Search pursuant to the warrant or at issue, nor can he, because they do not belong to him, and thus the defendant does not have standing to challenge the warrant of those accounts. The defendant's motion is therefore moot. Affirming the district court's determination that the defendant's motion to suppress was moot, and where the government informed court it was not introducing the seized evidence at the trial, even if the defendant's motion was not moot, and the defendant contained significant evidence to establish probable cause to search the bank's X account and the bank's X X account and an iCloud account. Although the court need not reach the merits, the affidavit had ample probable cause to search both of the defendant's accounts. Probable cause is not a high bar. Rather, probable cause is only a fair probability that contraband or evidence of a crime will be found in a particular place. Whether probable cause exists is based on the totality of the circumstances known to the officers. Moreover, the law enforcement may draw upon their experience and their expertise in determining the existence of probable cause. The experience of a trained law enforcement agent is entitled to consideration in determining whether there was probable cause. Both search warrants authorize law enforcement to search for evidence of various offenses, including violations of M for hire and conspiracy to commit M for hire, racketeering influence, and corrupt organizations, RICO conspiracy, and the violent crime in the aid of racketeering statute. Each warrant was supported by a substantially similar 35-page sworn affidavit from an FBI special agent. The affidavit detailed the special agent's 14 years of training and experience in M's and other violent crime investigations. The affidavit sets forth specific facts establishing that the Chicago-based hitman traveled to Los Angeles to unalive one of the defendant Banks's and OTF's rivals, and that defendant Banks ordered and financed the M plot. Among the evidence referenced in the affidavit is information provided by who's this? Who is this black providing this information? Nasty word. Based on information from CW1, here we go, and open source reporting, the affidavit explains that the defendant Banks placed a bounty on TB's life following the unaliving of an OTF member, Davon Bennett, aka King Vaughn. The affidavit further disclosed that CW1 knew that the defendant Banks placed other monetary bounties for unalivements of people whom the defendant Banks was feuding, including 6 other individuals. 6 other individuals is crazy. Okay. The affidavit also listed significant evidence corroborating CW1's account of the defendant Banks' involvement in SR's unaliving, specifically according to bank and flight records. An associate of the defendant Banks coordinated and paid for 5 of the co-conspirators to fly to and from Southern California using a credit card that was linked to defendant Banks and OTF. This is one of the worst things that happened to Durk right here. Them doing this. Great. If you ain't do this, bro, you got him saying, yo, don't book nothing in my name. All right, cool. But yo, this is major, bro. That. Why y'all even putting stuff in the name anyway, bro? Y'all ain't got money. That's weird, bro. Y'all just looking for a reason for people to tie it in. It's just crazy. This don't even make sense if this is true. Don't even make sense. Even if it's not true, what you doing? And just like, look, imagine it's not true, right? Okay, because remember, everybody presumes innocent until guilty, right? And it just looks like this. So y'all done used the man thing and got the man looking like this. Imagine, bro. Come on, bro. Y'all niggas is hot. And just like that, and just like the funding for the hitman's flights, records also show that the defendant Banks' credit card was used to purchase the hitman's hotel room the night before the unaliving. To establish, let me go check on my stream real quick. Hold up. Reading this shit like this all day. Facts. Okay. Let me read this shit out. All right, cool. To establish probable cause to search for evidence related to violations of the RICO and VICAR statutes, the affidavit also contains information about OTF's structure and history of violence. Specifically based on FBI special agents' review of law enforcement reports, conversation with other law enforcement agencies, and conversations with CW1. This person is important, bro. They keep citing. This is the main person, number 1. Okay, confidential witness number 1. That's who this person is. Who is this person, bro? We're going to figure out who this person is shortly because we're going to know. You know who's in your case. Durk knows who this person is most likely by now. He knows who this person is. Because you know who's telling on you in your case, you know who's the witnesses, you know this. The affidavit states that in addition to OTF status as a rap collective OTF also acts as an association, in fact, of individuals who engage in violence, including unalivements, assaults at the direction of the defendant.